Well, I have come up with some nuts and bolts for employers that are kind of the top things that they need to take care of correctly to keep themselves out of trouble. And one of them is having an employee handbook, and another is correctly classifying employees as hourly or non-exempt versus exempt or salaried. The third big trap is trying to call workers independent contractors that really are employees. And then the last is not correctly tracking time for hourly employees. Those are the things that I've seen employers get in trouble the most with. And I've been in practice 38 years, and I've developed a specialty in labor law from the management side. And I've been in the trenches on just about every kind of lawsuit you can think of in the employment area. But these are the biggies that'll really come back to bite employers, especially in the wage and hour area, because that's where the really big lawsuits are now, the big damages, and it's a very tricky area of the law, so you have to really be careful to keep on top of it and have good employment counsel who can give you good advice and help you audit your procedures and pay practices and how you're classifying your employees. Probably the costliest and most frequent mistake I see is improperly classifying their workers as exempt versus hourly. Part of that I'll deal with later also is not paying correctly, not tracking time correctly, but that's a whole nother ball game. But employers frequently will try to call an employee exempt so they don't have to pay the overtime, especially if it's somebody who puts in a lot of hours in the business. An example would be, say, an executive secretary or a department manager or something like that. But the Department of Labor has very involved regulations that spell out when you can treat an employee as exempt so that you don't have to pay overtime. And if you fail to meet those regulations, then you're going to end up either the subject of a Department of Labor investigation that they can initiate on their own, or someone can go to them with a complaint, and then you become the subject of an audit, which is not a happy thing. Or you may get a notice from an employee's attorney that they're filing a lawsuit against you, and that's even worse. The wage and hour lawsuits are one of the biggest areas of litigation right now, especially in the employment area, but even just across the board, because they're very lucrative for plaintiffs' attorneys. The lawsuit can be started with just one employee who claims they were treated improperly and not paid overtime or minimum wage, if that's applicable. And it's called a collective action. That employee gets permission from the court to have the employer furnish to them the names of all other employees that were similarly situated for the last 3 years. And the plaintiff's attorney then can send a notice out to them that says, "Hey guys, we're filing a lawsuit for pay. You want to join in?" And all they have to do is sign a consent to join the lawsuit. Most of the time, the plaintiff's attorneys handle the cases on a contingent fee, so it doesn't cost the employee anything to join in the lawsuit. And then suddenly the employer's not faced with just one employee complaining or filing a lawsuit, but tens, maybe hundreds or thousands of employees. And even if the amount of overtime that wasn't paid is not that significant for one employee, by the time you multiply it by however many join in the lawsuit, it can be really significant. And the other really dangerous thing about these lawsuits is that the amount of overtime that wasn't paid is automatically doubled as a penalty or a fine in either Department of Labor investigation or a lawsuit. And if there's a lawsuit brought and the plaintiffs are successful in having the court determine they weren't properly treated as exempt and they should have been paid hourly and overtime, then the court's in all likelihood going to grant a substantial amount of attorney's fees to the plaintiff's attorney, which you're going to have to pay too, in addition to your defense costs. So it's one of the kind of situations where it's not worth the savings that you think you might achieve on the front end if you've improperly classified somebody as exempt. I even had one client who was trying to be good to his employees, and he said, "You can work all the overtime you want, I just can't pay you time and a half, but you can have all the hours you want." And it was like, that was the worst thing he could have said, because he just laid the trap for himself. And as a matter of fact, these employees had worked a lot of hours, and were very highly paid workers, so it ended up costing him a ton of money. And in addition to that, in these lawsuits, you end up paying the attorney's fees for the plaintiff's attorney, and one employee can start the lawsuit, and the court allows that one employee to send out notice to any other employees who are called similarly situated, who have the same type of a job, who've worked for the employer for the last 3 years. And if there's any question in your mind, I highly suggest you consult with employment counsel who can help you go through and analyze the job and compare to the regulations and make sure that person really is exempt so that you aren't faced with these dire consequences.